Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we are talking about patent infringement. Cases that should have gone to the Supreme Court of Canada, but didn't. Apotex Canada was sued by Lilly Canada, two pharmaceutical manufacturing companies. The reason for the lawsuit was that Apotex obtained some of a lupin-2 cefaclor, whatever that is, that was owned by Lilly Canada. They used it to make a competing drug and ultimately sold it on the marketplace. Lilly sued Apotex, claiming that they had a patent for the cefaclor and that Apotex was not supposed to be using it. Ultimately, the court agreed with Lilly and awarded them $31 million in damages. However, they found that of the two patent infringements that were being alleged, only one was proven. The other patent infringement was not proven, and Apotex was permitted to continue manufacturing one of the drugs. The problem that arose in this case was that one of the drugs did roughly the same thing as the other drug, so the patent infringement was on the basis of a single drug, but amounted to the whole sales for both drugs. The court was asked to consider whether or not it was appropriate to award $31 million in damages, plus $75 million in pre-judgment interest, on the basis of the sales of both drugs, when only one infringed the patent. The court was asked the question of whether or not it was likely that the non-infringing drug would have sold in the place of the infringing drug had the infringement not taken place. And the Supreme Court of Canada was asked to hear the case. Now, this case is very complex, but it raises a very important issue, which is the question of how do you calculate damages for patent infringement when there are similar drugs, one which infringes and one which does not infringe a patent of another company? How do you determine the impact that the existence of the other non-infringing drug has on the sales overall and ultimately the damages? And is awarding financial damages for patent infringement really an appropriate way to deal with the problem in cases like this, where there's only partial infringement proven in the ultimate lawsuit? The Supreme Court of Canada had an opportunity here to clarify how patent law damages are to be awarded in circumstances like this, so that companies whose patents are infringed are not unjustly enriched by being given more money than they would otherwise be entitled to, or more than the value of their losses overall. This was an opportunity for the Supreme Court of Canada to make things a little bit more fair, albeit for gigantic corporations that have hundreds of millions of dollars to engage in this type of litigation. However, the Supreme Court of Canada missed that opportunity, and it's going to take another case of split determinations on whether or not a patent was infringed, with multiple substances being alleged as the infringing substance, for the Supreme Court of Canada to have this opportunity to address the issue head-on. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Thanks for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos, and like, subscribe, and share with your friends.